All right, good evening, everyone. Given that we're just a little bit past 5:30, I thought it might make sense for us to go ahead and get started. Just to introduce myself, my name is Brant Helwig. I'm a member of the tax faculty here at NYU, and I also have the privilege of serving as the faculty director of the graduate tax program. And really thrilled to welcome many of you back to NYU. I think a lot of you are here for your law school alumni weekend, so we picked a good weekend for it, right? If you're coming back to New York, it's really nice to have you here, and I hope you had enjoyed this lecture, our reception afterwards that we'll have just down the hall in the lounge area, and then I hope you enjoyed the rest of your weekend. But really, for those of you who have made the trip back for alumni weekend, it's great to see you, and I hope you have a fantastic time. This event is the Jerome Manning Tax Salon. This is the fourth installment of this particular series. And before we get started, I thought it would be nice to say a few things about Jerry Manning, for whom this speaker series has been established. So Jerry was a graduate of the JD program at NYU Law School, and he graduated in 1952. Not long after that, he joined the law firm of Strzok and Levan. There, he spent a career specializing in estate and gift taxation and estate planning. And Jerry went on to author what really is the definitive treatise in the estate planning realm. You gotta love this, Manning on Estate Planning. And it continues to be published by the Practicing Law Institute, and is now that treatise is now in its 7th edition. Jerry not only was an accomplished practitioner and prolific author in the estate planning space, he contributed significantly to the strength of the graduate tax program at NYU. He taught as an adjunct professor in the program for 40 years, and for 25 years he taught what is our capstone class in that field, kind of our estate planning course. He taught that again for 25 years. I'm not sure if anybody here in attendance had Jerry for that particular course. Those that had him, I hear frequently remember him fondly and always have great things to say about him. So Jerry has since passed, but we're extremely grateful to members of his family for establishing this speaker series. It's pitched as the Manning Tax Salon, I think with the goal of we hope to have maybe a little bit less formal discussions of current tax events. And so we are now in our kind of 4th installation of this particular salon. All right, so with that in mind, let me introduce our distinguished speaker, kind of convener of this year's tax salon, and that is Michael Schleyer. Michael is something of a titan, at least in my view, of the New York tax bar. He's a retired partner with the law firm of Cravath, Swaine & Moore. He is the past chair of the New York State Bar Association tax section. He continues to serve on its executive committee. Many of you know that the New York State Bar Association tax section puts out a number of specialized reports that analyze specific topics in the tax field. I don't know how many reports Michael has commented on, but
I'm told it's about 1,000.
Yeah, so
I haven't counted myself.
He is all over whatever materials that NYSBE puts out, and always makes significant contributions to those reports, whether or not he's the author. Michael chairs the New York Tax Forum and is a past president and current trustee of the American Tax Policy Institute. The list goes on. He serves as a member of the executive committee of the Yale Tax Reform Project. And he has consulted for the American Law Institute on federal income tax projects. Just a little background, Michael holds degrees from Harvard College, Yale Law School, and in my mind, most significantly, NYU School of Law. He earned his LLM Michael is a part-time student, is that right? While you were practicing as an associate, and we were just talking about this, he earned his LLM degree in 1979. Beyond all of that, Michael continues to be an active participant of the kind of the tax community here at NYU Law School. He's a frequent attendant to the numerous colloquia that we have. frequently attends our extracurricular events, including this event last year. And thankfully, Michael not only attends, but he actively participates, right? He's not shy. He poses frequently a number of penetrating questions, makes perceptive observations, and often contributes and enhances the quality of the discourse that we have here in the tax program. So we're grateful for his continued investment in what we have going on in the tax program here at NYU. So Michael is going to speak on the future of the tax regulatory process. Certainly an incredibly important and particularly timely issue. So with that, please join me in welcoming Michael to deliver our Manning Tax Salon series this year.
Okay, thanks, Brand, for that very nice introduction and for inviting me. I'm honored to be here to give this, well, I won't go to talk, let's consider it a dialogue. I hope people participate as we go along. I can't stand listening to myself talk for an hour without somebody interrupting me.
And I should mention, if anybody has questions along the way, Michael and I would mention this, please raise them and don't wait till the end, right? Usually having dialogue makes things a little bit more, less formal, which was what we're shooting for, and also more interesting.
Okay, just the first line, here's the summary of what we're going to cover so you know where we're going and you won't be surprised. Every tax legislation, and usually they're pretty elaborate these days, TCJA and the more recent ones, they all have glitches. I mean, some of them help taxpayers with loopholes that weren't intended. Some of them hurt taxpayers with provisions that weren't intended. People use provisions in unintended ways that Congress didn't intend. And so you need somebody who can really fix the glitches, whether they're pro-taxpayer or anti-taxpayer glitches. And the choices are Congress or the Treasury. I mean, Congress basically can't do anything. They haven't done a technical correction in many years. And so that leaves it to the Treasury, really. But we'll be talking a lot about Loper-Bright, which is, I don't know if people are familiar with that. It's a Supreme Court case from last year we'll be talking about a lot more. But basically, it adopts a very literalistic interpretation of the code, and it really makes it impossible for the Treasury to fix pro-taxpayer glitches in a statute that open up loopholes, because if the Treasury tries to fix it with an anti-taxpayer regulation, the courts will basically strike it down as invalid under Loper-Bright. On the other hand, if there's a provision in the code that unintentionally hurts taxpayers, Loper-Bright still in principle applies. But if it's a pro-taxpayer regulation to fix that glitch, nobody really has standing to challenge it, and that's a critical fact. Nobody has standing to challenge a pro-taxpayer regulation because nobody is hurt except the public, and they don't have standing. They're hurt because the government is collecting less money, and so everybody else has to pay more taxes in theory, but nobody has standing. So Loper-Bright has really exacerbated that problem of sort of a one-way street in favor of taxpayers, because the taxpayers really get the best of both worlds, the advantage of the pro-taxpayer glitches, and they get the anti-taxpayer glitches fixed by the Treasury. Loper-Bright also creates a lot of other uncertainties, and because of that, there's it'll create a lot of activity on the part of taxpayers, whether to follow regs if they like them or not follow regs if they don't like them. And it may give rise to a lot of different tax laws in different parts of the country as different courts interpret the validity of regulations differently, and we'll get to some of that. There are also some problems under the Administrative Procedure Act, where recent court cases have said Treasury has to respond to comments on proposed regs in a lot of detail, and that's made it very hard for them to put out regulations these days because there's so many comments and so many responses they have to give. You get these enormous preambles lately. And also, those rules have been applied retroactively to years before anybody knew those rules existed. So people can now go back and see if the work comments responded to on old regs when nobody thought the Treasury had to. And some of those regs have been invalidated for really, I would say, no good reason, but they have been. And we'll talk about that. And the last thing that's, I think, very important is that now that we have Loper-Bright, it was sort of a new standard to review by which regulations are judged for validity. Every regulation that exists, both tax and in the whole U.S. Code, is potentially subject to challenge to be invalid. The the Trump administration has asked every agency to come up with a list within 60 days, and the 60 days is already over, of every regulation that they, in their purview, that they believe is invalid or under Loper Bright or under a whole bunch of other cases and situations. And so at some point, the Treasury, and they say it's already overdue, is in theory supposed to come up with a list of every regulation that it thinks is not valid, without distinction, at least on the face of it, between pro and anti-taxpayer regulations. And there are a lot of regulations that people rely on every day that might be in that category. Just to give two examples, we'll get to more later. You know, thinking about check the box regs. I mean, what makes those valid? If you have a U.S. corporation, a real U.S. corporation, what in the code says you can elect to have that be treated as a partnership? Or you have a foreign corporation, what in a real corporation, what the code says you can elect to have that be treated as a partnership? You know, there's pro-taxpayer options, but they're not valid under Loper Bright. And by the way, all of carried interest is also invalid under that theory, because that is inconsistent with Section 83 when you give a transfer of partnership interest for services. 83 says you look at the fair market value of the partnership interest. Loper Bright, and that's what Loper Bright says, you follow 83. The IRS says, no, you look at the liquidation value of the partnership interest, which is zero when it's given. So, you know, it could upend a good part of the code if Loper Bright is taken literally. Okay, now that's a summary of where we're going. Now, so as I said before, tax legislation often has a lot of glitches. For TCJA in 2017, the Joint Committee Blue Book they have footnotes every time they give a statement of what they think congressional intent was, but if the code doesn't quite say that, there's a footnote saying this may have to be fixed with a technical correction. There are more than 70 of them in that Blue Book, and then there's a later Blue Book for later legislation that has 25 more. And that was back in 2017 that TCJA passed, and no technical corrections have been passed since then. I mean, one of the reasons is the only way Congress can ever pass tax legislation these days is through a reconciliation, because you know, the Senate is divided, and there's a Senate filibuster for anything other than a reconciliation bill, and a reconciliation bill has all sorts of restrictions, and it appears that technical corrections are not eligible, although ultimately it's up to the Senate parliamentarian, but that seems to be the rule.
Can I ask actually, because when I hear that, I never know, I've heard that before, does that mean they cannot even be part of a broader reconciliation, or you're saying they couldn't on their own be that?
No, for reconciliation, every provision has to stand on its own as being eligible for reconciliation. You can have 100 provisions, and if one of them isn't eligible, then somebody can do a point of order and have it pulled out. That happens a lot in TCJA.
Regardless of like revenue.
Right. It has to. Yeah, because it's not changing the law. I mean, there's another rule that every provision has to have a revenue effect,
right.
And it's not clear this even has a revenue effect compared to what was intended originally. And then you get into the question: do they use current law or current policy as the baseline? But it appears, as far as I can tell, that technical corrections just aren't eligible.
So, Mike, in the past, it was quite common when we had major tax legislation for there to be, in the following year or so, a technical corrections bill, right, that was passed. We didn't have to worry about reconciliation because we were talking about technical corrections. That wasn't so much of a uphill partisan battle. If there are simply errors that we had in the tax legislation that needed to be fixed. So it wasn't so hard, even if we had, I'm sure, I guess back at the time, kind of a 60 vote majority.
Oh yeah, the 86 Act. The 86 Act had a major technical corrections bill 2 years later in the 80s, the 90s. It was sort of routine. Everybody did it. But now the only way the bills are passed in the first place, like TCJA was it was a reconciliation. There was not a single Democratic vote for it. It was all Republicans. And on the Biden, the Inflation Reduction Act had only Democratic votes, not a single Republican votes. And neither party is, if the Democrats pass a bill, the Republicans say, we're not going to help fix that, the corrections in that, and vice versa. So
if the party's frozen out in the process, they're not going to be eager to help you clean up whatever mess.
That doesn't work. That's your problem. Don't bother us. Fix it yourself.
So that leaves us with really Treasury, the only one is in a practical position to try to correct these types of mistakes. I know you're going to talk about.
Yeah, and now the problem is it's really hard for them to do. And just as a little background, before Loper Bright, there was Chevron starting in 1984. And under Chevron, if the statute was clear, then it couldn't be changed by a regulation. And some of the things we'll be talking about might have failed Chevron even to try to fix. But absent the statute being clear, if it was what's called silent or ambiguous on the precise question, then as long as the agency, the IRS adopted a reasonable construction, it was okay. So all you had to do is get over the hurdle of being clear, and then basically the Treasury could do whatever it wanted if there was the slightest ambiguity in the statute. There was a lot of flexibility, and it was very hard to challenge a regulation because unless you could claim the statute was completely clear. But if the Treasury got over that hurdle, they would usually win because unless it was such an off-the-wall regulation, and that was very rare. Now, even based on that, though, as I was saying, if the statute was clear, the courts tended to follow the literal language. And Gitlitz, which is a Supreme Court case, was a good example of that, where the subchapter S regulations gave what the court acknowledged was a double windfall to taxpayers, the way the basis rules worked. And the court said, well, that's just stuff. Congress can fix it, and we're not going to let the Treasury change that. Then we get to Loper Bright, which was last year. And that explicitly overrules Chevron and says a regulation is valid only if it's the best reading of the statute. No reasonable judgment or anything. It's the best reading of the statute. So when you had Chevron, the tests for validity of a reg were if the statute was 100% clear, then that was the end of the story. Other than that, there was between, let's say 20% for the minimum reasonable standard. Between 20 and 99, the Treasury had complete discretion. If a statute, say, if a court would have said, well, there's a 20% chance this reg is consistent with the statutory interpretation, or up to 99%, the reg would be held valid. Now, all that is gone, and the only test now is 51%. If the reg is consistent with what the court says is the best reading of the statute, then the reg is valid. If the reg adopts a position the court says is not the better reading of the statute, the reg is invalid. Now, the court may give some deference to the Treasury in a close case in determining what the best reading of the statute is, but the ultimate test is 51%.
Michael, if I could just jump in with one example that might highlight how Chevron operates in relation to Loper Bright. So I often think of the concurring opinion that in the Tufts case that was issued by Justice O'Connor. The question is, should we include the full amount of the non-recourse debt relief when we have the transfer of property subject to that debt? Should we include that amount even though that amount exceeds the fair market value of the property? Justice O'Connor said really the best way to do that is to treat recourse debt and non-recourse debt the same. We should have limit the amount realized to the fair market value of the property, and the rest really is discharge of indebtedness income. That was her whole point in that concurrence. But she said, but the way the IRS is treating it is not like off the wall, right? It's not unreasonable. So we're going to uphold the validity of the 1001-2 reg, right? Now, if at least from that perspective, if you really believe that that regulation is not the best interpretation, you would, under Loper Bright, the idea is now we're going to have to, because my interpretation and I am a judge and we're in the best position, we are the best suited to interpret the statute, we would say that regulation is invalid.
Right. Every regulation is up for grabs. Any taxpayer can take a position and litigate it, and maybe they'll win. You never know.
Right.
As I said just before, the Loper Bright does contemplate that agencies will get some, of course, will give some deference to agency interpretations. That's called Skidmore deference, which was the rule before Chevron. So we're sort of back to that. But ultimately, and there have been some recent cases saying, well, they'll give some respect to the IRS, the Treasury, but ultimately it's still their decision what's the best reading of the statute, even though they can take the Treasury's position into account. Loper Bright also says that the Treasury can act in accordance with any authority delegated to it in the code. The code has all sorts of different delegations, ranging from fairly specific delegations that say provide rules for this circumstance, or there's the general delegation in 7805 authorizing regs to prescribe all needful rules and regulations for the enforcement of this title, whatever that means. there's going to be a big controversy in future cases as to how broad that is. And the cases since Loper Bright have tended to ignore that on the theory that they still have to determine the best reading of the code, and they'll give some respect to the Treasury, but I don't know how much more respect the Treasury is getting because of 7805, and if 7805 wasn't there at all. The first major case that came out after Loper Bright was the Varian case, which was really one of the cases I was talking about, where there was a clear glitch in TCJA that literally gave the taxpayer both a credit and a deduction for the same foreign tax. That's just the way the sections fit together by mistake. And the tax court, in a unanimous decision, it was reviewed by the courts and it was unanimous, said, well, no, even though you might argue that the Treasury was delegated some authority, you still can't overrule the clear language of the code, even for something that's clearly unintended.
So, Mike, one thing that's interesting about the Variant case is the tax court seemed to make a big deal, like, hey, now that we have Loper Bright, our hands are tied on this, and it's, don't blame us, blame Congress, and it's up to Congress to fix it.
Yeah.
Interesting. I think that you could easily get to that same result under Chevron, under your 100. Like, it was, the interpretation could not be reconciled with the plain text of the statute that was just an error, right?
I think that's right, but I think after Loper Bright, there's even more force to that. It's a recent decision. They came out very strongly in favor. Chevron is sort of an old decision.
Right. There certainly is a vibe shift once Loper Bright is out.
They know if the case goes to the Supreme Court, how it's going to come out.
Right.
The Supreme Court. They know, so they don't want to get reversed.
Right, and I think it also gives them the courts, if they're inclined to overturn or declare a regulation invalid, as they were in this particular instance, I think it just makes it easier, right? Because they're pointing to Loper Bright, saying the Supreme Court is telling us that we don't need to afford the same level of deference to the agency. Yeah.
And it's just safer for a judge to uphold what they think is the best reading of the statute, because they probably won't get reversed if they do that. To come up with some argument, well, maybe we give enough deference to the Treasury to change what's likely the best reading. It's sort of a risky position for a judge if they want to have a good record of not being reversed on appeal. Variant is also interesting because aside from the Loper Bright theory, the best reading of the statute, is what's called the absurd results doctrine that's been around for a long time, that says if the result of a literal interpretation is absurd, then we just won't adopt it. The Variant court said, well, it's not absurd enough to give both a credit and a deduction for the same foreign tax. It has to be more absurd than that. Yeah. And if that's your standard, you can forget that doctrine, because that's about as bad as you can get.
Right. Well, Gitlitz too is.
Gitlitz is it's true. Gitlitz was the same kind of absurd result, though this is probably even more direct. Yeah.
Yeah. So after Loper Bright. After Loper Bright, you're talking about, so it seems like regulations are now afforded the same, give more deference as a revenue ruling or other forms of Treasury or IRS Council guidance. And so it seems to me that it means that there's very little benefit to going through the APA standard and the notice and the comment and all of the hoops that we would like government to go through in order to enact these rules, but instead should just put out revenue rulings or revenue procedures or similar sorts of guidance that receive the same amount of deference, presumably.
No, I don't agree with that. And the reason is that when they go through the whole process, they can show the court that they've gotten the comments and they've responded to the comments in the preamble, so they've laid out their reasoning for almost any objection somebody already made. And so it shows that they really thought about it, assuming they really thought about the issue and wrote it down. That's why preambles are so long. I think even now they'll be even longer, because the preambles now are going to be like briefs. Because they know the court is going to be evaluating every reg to see if it's consistent with the statute, especially if it's an anti-taxpayer reg that can be challenged. And so they got to get their 2 cents in early. And if they can show somebody made the comments when they proposed the reg and then they responded to it, I think they hope that they'll get more deference than just some revenue ruling that doesn't give reasoning usually and doesn't show responded to comments. So I think it's likely to make it more important for them to put out regs.
So the idea is going through that whole notice and comment process and having it documented I think would bolster their argument, the agency's argument, that our interpretation that we came up with after this thorough process is actually the best interpretation of the statute.
Okay, now another issue that comes up, Luper Bright kept referring like 6 times to it's okay to have delegations to the agency, but every time it talked about constitutional delegations. And nobody has really worried very much for the last 150 years about 100 years about what delegations might not be constitutional. But back in 1935, the Supreme Court in Schechter-Poultry said that a delegation was unconstitutional. That was the last time, 1935. But not, you know, surprisingly or not, the current case in the Supreme Court, the FCC case, that is, raises the question of what's a constitutional delegation. And so in the next couple months, we may know the answer to that. And we may know whether 7805 is a constitutional delegation, because the old standard and the current standard has been whether the delegation provides an intelligible principle for the agency to put out regulations. Now, you might say 7805 doesn't even meet that, but regardless, assuming it meets that, because everybody's been relying on 7805 for a long time, it's very possible the Supreme Court will come up with a stricter test, because many, either 4 or 5 existing justices in various concurrences or dissents have said they thought the standard should be tightened. And finally, they granted cert in a case that raises the issue. And so it's very possible there'll be a stricter standard. And the code delegations vary from the very general ones like 7805 to another one, my favorite, 1275D, that authorizes any change in the statutory rules to carry out the purposes of the rules. Even broader, 1502 authorizes any consolidated return regs they want, even if it's not consistent with the other code provisions. I just can't imagine a judge saying that consolidated return delegation of authority is unconstitutional and then trying to come up with their own consolidated return rules. But I just don't know what might happen there. But anyway, we'll find out in the next few months, at the end of this term, by the end of June, I think, the end of this term, whether what the standard is. Some people in that case, by the way, the people objecting to the grant of authority in that case actually involved the fee setting for the FCC setting fees for on telecommunication providers for universal service in rural areas, and they're arguing that as if it's a tax case because a fee is like a tax, and the people objecting to the delegation as unconstitutional are saying there should be a stricter standard for tax, allowing less delegation than for anything else, because the Constitution specifically puts the taxing power in Congress, and so there should be a stricter standard for delegating it. Now, so far that has not been the rule. The rule has been uniform, so we'll see what happens for that. The FCC case, also on a different topic, involves the FCC actually arguably subdelegated the right to set the rate to a private charitable organization. It wasn't really a delegation because the FCC had the final say, but to the extent that's a delegation, the ability to constitutionally delegate might also come up in that case, and that could affect the constitutionality of things like CAMT, which are based on book income, and there's other provisions of the code based on book income also. I mean, is that an unconstitutional delegation to FASB? I don't know. We'll see. Hopefully not. Okay, so going back to, in TCJA, just to illustrate what I was saying about the lack of balance in the system, the Treasury put out a lot of regulations to close gaps in the, there were a lot of gaps and they tried to close some. There were a bunch of pro-taxpayer regulations like the guilty high tax exception and some of the BEAT regulations that clearly were not authorized by the statute, but they put them out anyway and they're pro-taxpayer and nobody can challenge them. They also put out some anti-taxpayer regs to close what were clearly unintended gaps in the statute in guilty, where you can have situations where there's some guilty income that's just never taxed in the system, just the way the rules work. And those regs, while they put them out, there's a good chance they're going to be held invalid. So it's back to that one-way street in favor of the taxpayer. the same principle arose under Chevron, but it's worse under Loper Bright because more anti-taxpayer regs will now be invalidated. So the gap between that and the pro-taxpayer regs that will remain is just bigger. And I think there's really no justification to have an asymmetric system like that. I mean, the Treasury should have no more power to give away money to taxpayers that Congress didn't intend to be given away than to take money from taxpayers that Congress didn't intend to be taken. That seems the right rule to me, but that's just not where we are right now. And another big issue under Loper Bright is what's going to happen to anti-abuse rules. Things like, I mean, it's even more important now than before because if the Treasury can close, gaps in the statute that taxpayers can take advantage of, if they can't close it by regs, I mean, it's more important than ever for taxpayers not to be able to plan into it than take advantage of it by gimmicky kinds of transactions. And so, I mean, I think things like step transaction and business purpose is still valid. That's always been built into the tax system, and there's nothing in Loper Bright that says it's no longer true. I mean, the partnership anti-abuse rule, which wasn't really being used by the IRS very much, but has been more recently, I think that's probably at a big risk because that's not in the code. I view that as sort of gone. I mean, the bigger issue right now, I think, is the economic substance doctrine, which is in the code now. And so there's nothing literally in Loper Bright that says you don't apply that part of the code. It's just like you apply the rest of the code. The problem is that the economic substance doctrine applies under the code only when it's relevant. And relevance is based on congressional intent as to whether the result you got was intended by Congress or not. Because, some results that really don't have economic substance, like some of the low-income housing credit deals and all, they don't have substance, but Congress intended it to be just the credits to be a subsidy. And so you ultimately have to look at congressional intent to see if the result was intended or not before you apply economic substance. And Loper Bright, is so much aimed in favor of literalism that it's sort of hard to know now whether that aspect of congressional intent to determine whether the economic substance doctrine applies is still going to stand up. And it may be that courts just weaken the scope of the doctrine, or maybe the Treasury even weakens limits the cases where they apply it, which both I think would be very unfortunate because certainly when the Treasury has less power to close loopholes in the statute, some taxpayers will just automatically fit into them without even trying, and that's the way it is. But for people that plan into it, it seems to me it's important for Treasury to be able to at least stop that. Loper Bright also creates a lot of uncertainty. Taxpayers have, as we were saying before, incentives to challenge regulations on the theory they're not the best reading of the statute. I mean, there'll be a lot more disagreements among courts now than there used to be because before, when the only test was, well, is the regulation reasonable? A lot of people will think a regulation is reasonable without even trying to figure out whether it's the best reading or not. And a lot of court cases, they didn't even worry about best reading. They said, well, it's not the reg isn't 100%, the statute isn't 100% clear, the reg is reasonable, that's end of story. And so that most courts would probably agree most regs were reasonable under that standard. Now with the test being, well, is it more likely than not the right interpretation of the statute, there's much more room for disagreements because the courts that think, there's only a 30% chance that this reg is the right reading of the statute, they will now come out the other way. Before they would have upheld the reg, now they'll invalidate the reg.
So, Mike, one of the things that this makes me wonder is, were the courts not busy enough beforehand? And because before, if you have Chevron deference, then there's not going to be nearly that many reg challenges that are brought because they know the likely outcome. It would have been limited to instances where the taxpayer thought there was simply an inconsistency. The regulatory interpretation wasn't permissible at all under the statute. But now, given that it is going to be, hey, well, everyone can make an argument as to that this particular the Treasury's interpretation is not the best. It's reasonable, but not the best. Now we're going to basically have courts slide in to say we're going to be the ultimate arbiters of interpreting the code, not the Treasury Department. It's going to, in my mind, create this exponential growth in that type of litigation. which is I think what you're saying. Now we're going to have different potential for circuit splits. But
Yeah. Also,
there's a lot more work. Maybe the courts just needed more filing fees. And
Also, you're just focusing on tax. This is the whole U.S. code we're talking about.
Right.
It's every regulation. If the code, the U.S. code puts the tax code to shame in terms of how big it is. I mean, the government will get to this, but every government agency is supposed to look at every regulation to see if it's consistent with Loper Bright. Loper Bright was not a tax case. It's just being applied to tax. And so, so throughout the whole legal system, taxpayers then have strong positions to disregard regs. There'll be less risk of penalties if they're wrong, if they have a plausible argument a reg was invalid under Loper Bright. The courts will disagree. And also it takes years, if a reg comes out today, even if it applies this year, the return isn't filed until next year, at the end of next year for corporations. It won't be audited for a couple of years after that. It won't get to the courts until after that. If they go to even if the Supreme Court doesn't take the case, it'll be years before the Court of Appeals gets the case. And until then, people can take whatever position they want. I mean, everybody in the whole country, if there's some argument that it's invalid. So even if the reg is ultimately held valid, there'll be years of people maybe taking positions as invalid, and there are not that many IRS agents left to audit all these returns, and so people are going to get away with a lot. And also, different, even if courts, if courts come out differently, different Court of Appeals may come out differently. The Supreme Court cannot. Is not going to do a lot of. They don't do a lot of tax cases now, and they're not going to do a lot more if they get after all this, because they have the whole country to worry about. And so there may be a lot more splits in the circuit, which will be permanent, and which means there'll be different tax law in different parts of the country. And then if you're not in one of the circuits that even decided the case, then you can follow whichever way you want, whichever is better for you. Each taxpayer can choose. So at least potentially, as the years go by, this could really have a lot of effects. Another sort of parallel issue to this is, the Administrative Procedure Act requires that regulations be accompanied by what it calls a concise general statement of the basis and purpose. And before 2011, that was interpreted very loosely for tax regulations, and preambles were pretty short. They would cover a few issues, but they were very short. And then more recent cases, like the Altera case, was one started imposing much stricter standards on what the preambles have to say in response to comments. And so even aside from wanting to write extensive preambles to convince a judge that to give deference to the substance of the rule, preambles have gotten longer in recent years because the courts have said if you don't reply, if the Treasury doesn't reply to all the comments, the reg will be invalid, totally aside from what it says, just because on a procedural grounds they didn't comply with the APA and putting out the reg by giving a detailed response to all comments. And so that itself has made preambles longer. And the real problem is the courts are applying that new test retroactively to the time when nobody knew you needed the extensive preambles. And so there have been regulations invalidated because the Treasury followed what they thought was the test before for preambles, and now it's a stricter test, and they're sort of out of luck. And there have been a few judges saying, well, we understand it's sort of a problem, but tough luck. I mean, you should have known better back then, what the court would say now.
We got a question from John over here.
Oh, I'm sorry.
Hi. Yeah, right over here. You're talking about the EPA case, I believe, which came up in where some of the states had an issue with a regulation that the EPA proposed and felt that the EPA didn't take their concerns seriously enough. I'm wondering if the court took this especially seriously because these were states, these were sovereign states, as opposed to somebody who was, filing a concern. I think it might be looked at differently based on who's making the comment. That's my only thought about that case.
No, I'm thinking of tax cases.
Mm-hmm.
No, there were tax cases also with
Some of the conservation easement cases,
yeah,
right?
Yeah, there are several tax cases where they said, well, you just didn't. Even Altera said you didn't. Even though Altera said they actually considered the comments, but they didn't respond sufficiently. And so the preamble just got longer and longer.
So you can't get rid of this stuff by saying all comments that have not been specifically addressed are irrelevant or lack merit.
That's
right?
what they used to say.
Right.
That's why the preambles were short, but not anymore. Now, the one hope for this issue, for the retroactivity, is, I mean, Corner Post says is a statute of limitations case for Loper Bright, and it says that what the statute says, the statute for the APA says that 6 years from the time of the injury. For a substantive challenge to a regulation under Loper Bright, everybody thinks there's no limit because you can always find a new taxpayer that hasn't been around, and so they were just injured for the first time. And so there's effectively no statute of limitations for a substantive challenge for the best reading of the statute. But there's a footnote in Corner Post that says, well, maybe the statute is different for a procedural challenge to the APA, like they didn't respond to comments. So it's possible that after 6 years from the time the reg is finalized, that the time is up for making these procedural challenges. But nobody knows the answer to that yet. People will certainly be trying until that is settled. Okay, now maybe the most interesting part of this is the Trump administration on February 19th put out an executive order saying every agency is required to determine within 60 days, which is by April 21st, which is now over, every outstanding regulation in its jurisdiction that is not in compliance with Loper Bright plus a bunch of other things. And that was reinforced with another presidential memo April 9th. Now, you might say, well, that's sort of ridiculous. How can anybody thumb through the code, let alone everything else, and figure out what's consistent with Loper Bright? I've read that Elon Musk came up with an AI program and ran 100,000 pages of the Code of Federal Regulations through it to figure out what's consistent with the statute, each underlying statute. What happened with that, I have no idea, but that was a report that he did that. But anyway, so supposedly all that is done now, and the presidential memo says that the agency, including the Treasury, must immediately take steps to repeal any regulation that clearly exceeds the agency's statutory authority under Loper Bright. And if it chooses not to target one of those regs for repeal, it has to notify OIRA, the Office of Regulatory Affairs. And so supposedly, in theory, the Treasury knows every regulation now that's invalid, and it's supposed to immediately repeal them. And normally, the APA has this rule that you have to give notice and comment to repeal a reg. You propose it, then you get comments, then you consider the comments, and you finalize it. But the presidential order now says, no, we don't care about that. There's a good cause exception in the APA for situations where notice and comments are unnecessary and contrary to the public interest. And their theory seems to be that it's contrary to the public interest if a reg is clearly invalid to keep it outstanding during this long period it would take to repeal it. Now, nobody's ever thought the APA, that exception went that far, but that's what apparently they're trying to do. Now,
So, Mike, has any agency published their list of regulations that they believed are not consistent with the Loper Bright standard?
not that I know. The Treasury actually came out with 4 or 5 that were, I don't know if they were consistent or not, but they're really deadwood. And they about a week ago, they published that list, and they were really unexceptional. They were really old statutes that couldn't possibly arise anymore. And they apparently applied on that theory. But even then, they didn't quite follow that rule. They said, it was on April, it's really in the next slide. Yeah, this slide. They say, well, it's repealed effective June 16th, but if anybody objects, by May 15th, we'll reconsider. So they didn't even follow what the presidential order said. They gave some time. They immediately repealed it, but with a delayed effective date. They also put out, every year they put out a request for comments for what's going to be on the next year's business plan. But before that latest order came out, they asked for comments on what should go in the business plan, and specifically asked for comments on whether the proposals would be consistent with Loper Bright or not. So they were sort of asking for comments on that. But nobody knows whether what they're going to do about this new order to immediately put out regs based on the good cause exception, or repeal regs based on the good cause exception to the APA. I mean, one interesting feature of that is, can anybody, suppose they do that and they repeal a bunch of regs, and let's say they really are inconsistent with Loper-Bright, that they were pretty careful about that, can anybody challenge that method of repeal? I mean, if you're helped by the repeal, you don't have any standing because you're not injured. If you're hurt by the repeal, what you're really arguing, what you're really arguing is that you were entitled to rely on this reg that is clearly invalid under Loper-Bright, and that the Treasury has announced they think is invalid under Loper-Bright. I mean, it's sort of hard to make that argument that you had that entitlement. It's kind of, normally you can rely on regs based on estoppel. Although there is one case recently, the Memorial Herman case, that makes it questionable whether you can rely on a reg that's a pro-taxpayer reg that's inconsistent with Loper-Bright. But they didn't discuss estoppel there, so I assume you can until somebody tells you otherwise. But once the Treasury has announced, even not in the right way, that the reg is inconsistent with Loper-Bright, it's sort of hard to say you can still rely on it. So I'm not sure anybody can really challenge that use of the APA to repeal the regs immediately. Do you have a question?
Well, yeah, I was going to comment that this sounds familiar, and this is really obscure. I only know it because I haven't been involved in it. But under 6033, they, the statute says that organizations that are described in 501c3 have to file certain things to include the names and addresses of significant donors. And the Treasury removed that through a revenue procedure for organizations that were not 501c3. So regulations that were promulgated after that stated that to every organization that was exempt under 501A. So then, more recently, they said, okay, we're going to go back to just 501c3 because that's what the statute says, and they did it in a revenue procedure, and it was actually challenged with the governor of South Dakota, Norfolk Bullock. Bullock's a case, and it's a district court case, and there, the district court judge said, no, because it was passed through a notice and comment procedure, to remove it, to change it, you have to use a notice and comment procedure. And so the Treasury was not able to change it using just revenue procedures, instead was able to, or had to go through it. So then the Treasury did that, and they went through notice and comment and changed the regulations. But that seems like it seems like the exact scenario that we're talking about. But this was also pre-Loper-Bright.
Yeah, I mean, it might be harder for the Treasury to change a reg with a revenue procedure than even a failed use of the APA, but I see the point. Yeah, that's a good analogy.
Okay, one more question, Mike?
Oh, yeah.
Quick question. So technically they could identify other regulations, right? And arguably there's tons of regulations that don't respect Loper-Bright. It's a 42 regulations, check the box for inefficient. Those are out of thin air, right? To a large extent. So do you think they might actually in practice identify regulation that could have real major impact?
That's the next slide. We'll get to that. That's the final issue. That's the final issue. Okay, so yeah, so Loper-Bright, as it doesn't depend on whether a reg is pro or anti-taxpayer. The executive order doesn't depend on whether it's pro or anti-taxpayer. This is everybody's going to be lobbying now for the Treasury and all the other agencies to get rid of the anti-taxpayer regs. The Treasury asked for comments on what it should do. I mean, the reality is that a lot of people are going to be sending in comments saying that anti-taxpayer regs should be repealed, but I suspect there aren't going to be very many saying that pro-taxpayer regs, like check the box, should be repealed, even though logically it's exactly the same issue. And the Treasury has the obligation, and every agency has the obligation, as I said before, to tell OIRA every reg that violates Loper-Bright that it's not asking to be repealed. If it chooses not to ask Treasury to repeal, check the box. Are they going to tell OIRA this is on our list that we're not repealing, or are they not even going to say anything?
I think they're not going to say anything.
Maybe they won't say anything. But just as examples now of regs that we're talking about, you know, some of the pro-taxpayer, these are all pro-taxpayer regs that we'd be talking about logically should be repealed after Loper-Bright, but probably won't be. There's the obvious ones under TCJA, the guilty high tax exception, which I never thought had the slightest chance of being valid. There's some BEAT regulations that exempt a lot of things that probably aren't valid. They exempt a bunch of, well, they expand 199A by narrowing some exclusions to 199A for if the principal asset of the business is the reputation and skill of employees, that's supposed to be excluded from 199A, but they basically put it back. Brokerage services is supposed to be out of 199A, but they put back real estate brokers and insurance brokers. And so there's a lot of stuff in the TCJA that they sort of gave back. They gave to taxpayers that aren't in the statute. But then beyond that, there's a whole list, and this is just a brief list of all the regulations people rely on every day that pretty clearly are inconsistent with the statute. I mean, as I say, carried interest has no basis whatever in the statute. The check the box regs have no basis in the statute. You know, 1031 like-kind exchanges, which use qualified intermediaries. The reg says that the QI is treated as not being an agent of the taxpayer. I mean, that's just crazy as a substantive matter.
Even though you direct the QI, everything.
Right. You don't even give the money to the right. Nothing happens. It's just a piece of paper there. But that's what how would that stand up under best reading of the statute? You know, all real estate is like kind for 1031 exchanges, even though they might be totally different kinds of real estate. The 355E, which is the spin-off rule, when you have a 50% change of ownership, there's a super safe harbor, which is in the face of a statutory provision saying there's a presumption of the test is whether there's a plan within a period of time. There's a statutory presumption of a plan, but the reg gives a super safe harbor that if you meet that, there's automatically no plan, even though there may well be. If you do debt financings, there's a reg that allows qualified reopenings where you have an issue of debt, and then after a period of time you want to issue new debt, and you want it to be fungible with the old debt, but to have it be fungible on the market, it has to be fungible for tax purposes. And for that, it has to be part of the same issue. And so they say, well, we'll treat it as the same issue, even though it's really not. You had no plan to issue it originally, but we'll pretend there was a plan, which is perfectly good reasons for a lot of these rules, but they just are inconsistent with the statute. So the question is, what is the Treasury going to do with any of this? And the answer is probably nothing.
Yeah. Mike, I think if I'm at the IRS and I'm responding to this executive order and I start to identify these pro-taxpayer regulations that a lot of people know and love and have built, industries around, if I'm thinking to myself, hey, I didn't get fired in this latest round of layoffs, that would be a good way to go about doing it, right?
Well, I'm counting on the NYU Tax Law Center to put in comments on all the regs that they think should be. Where's Chai Ching when we need her? I hope she will. I hope she will. I hope they will put in a long list of say, well, if you want to repeal all these pro-tax, these anti-taxpayer regs, here's some pro-taxpayer regs. Oh yeah. There's not going to be a lot of people willing to put their name on a statement saying check the box regs or.
Look, from an equity standpoint, then maybe the number one thing they should identify is the pass-through entity state taxation that is not reported as a separately stated item, right? The idea that we can get around the SALT cap for business owners, but we're not going to, for all you other folks who are mere employees, we're not going to allow you to get around the SALT cap. That would be one.
That would be one too. Yes, absolutely. And so, so then the answer is, what is the Treasury going to do? They might as well, as I said, the anti-taxpayer regs that are inconsistent with this statute, they might as well repeal those because they'll get eliminated by the courts anyway. You might as well save taxpayers the trouble of challenging them. If at some point it's going to be so clear they're not valid, taxpayers will ignore them anyway.
Mike, you got a question up here.
Oh, sorry.
Any thoughts as to which ones are going to be put on that list?
Some of the guilty regs that try to close some gaps.
385.
Yes, the 385 regs. Oh, the excise tax on stock buyback, the funding rule for stock buybacks is pretty clearly invalid. They already withdrew the partnership basis shifting regs, which were pretty clearly invalid from the day they were issued. although they did keep the revenue ruling that applied the economic substance doctrine if you plan into it, which I think is useful. But there's a
Is there any kind of timing or period? You know, we're talking about regulation that maybe go back 30 years, right? I mean, realistically, are we really looking at those potentially being subject to challenge, or is there like a realistic statute of limitations? I know for the APA process, you say 6 years, but like on the other side, on the Loper Bright side, is there any comfort that you can have like old and code regulations people have been applying for 30 years, that those are be kept alone?
I mean, for pro-taxpayer regs, you know, I think a court would probably be reluctant to overturn them if somehow they could. But if it's an anti-taxpayer reg, I don't think there's any limit. You know, another problem is that, you know, a lot of regs help some taxpayers and hurt other taxpayers. I mean, many regs, even regs that mostly help taxpayers, may hurt some taxpayers and vice versa. I mean, what do they do about those? I mean, if they think they're inconsistent with Loper Bright, do they withdraw them on the theory they're inconsistent, which means they're hurting some people even though they're helping other people?
Depends on who they help and who they hurt.
Well, that may be, but they may not know. It may help some multinationals and hurt other multinationals.
Okay, gotcha. Okay.
Because multinationals are in different foreign tax rate positions. Sometimes they'd rather have guilty income, sometimes they'd rather not. That's why like the guilty, the high tax exception. Some people make the election and some don't, because some people would rather have the guilty income and get a foreign tax credit. Other people would rather not, because they can't use the foreign tax credits. And so people are in very different positions, and so some regs really have different effects on people. And so, you know, they may have a really quandary as to what to do about some. And I don't know how they'll come out on that. And, you know, one thing I suggest here is that, well, maybe Congress should just, by legislation, ratify all existing regs. So nobody can ever challenge any reg that's been adopted through today. It would solve a lot of problems. That is not an unconstitutional delegation, because Congress legislating a reg. There's no delegation whatever to the Treasury. It's whatever they did in the past is ratified. It's new law. That may be retroactive, but it's new law. Now, of course, there are taxpayers who were hoping that some of these anti-taxpayer regs will be invalidated by the courts, who wouldn't like that, because they'd rather take their chances in court. But it would certainly eliminate a lot of problems. I'm sure that I don't know what they could do, you know, at least to try to keep any balance in the system, because taxpayers are going to keep taking advantage of the loopholes, and there's no ability right now to change it unless Congress sort of gets their act together and, you know, on a regular basis tries to close loopholes, which they haven't shown any ability to do because of the just the way the legislative process works.
So, Mike, one thing I was thinking about when you mentioned the process of Congress simply enacting all the existing regulations, the Supreme Court in Loper Bright took a modest step in that direction by saying if any regulation had previously been challenged and upheld under the Chevron standard, then it's good. Even though it might fail the new Loper Bright standard, we don't get to go back and that's a narrow set of regulations.
That's not really, they said that, but it's not really true when you think about it.
Okay.
The reason is that, sure, if the Third Circuit, let's say, I'm just making up a court, said a regulation is valid under Loper Bright, sure, that binds, the Supreme Court is saying that binds the Third Circuit for the future. They won't change it probably. But any other circuit, they're not bound by the Third Circuit, even if the Third Circuit applied the same standard that the new circuit is applying. But if the Second Circuit is considering the same regulation, and they see, normally they might defer to the Third Circuit, but they see the Third Circuit didn't even use the right standard anymore. Why wouldn't they apply? And if they think, let's say the Third Circuit upheld a reg even because it was reasonable, but it may not, maybe not be the best. They may not even decide whether it's the best reading. All they had to decide it was reasonable. Now, why should the Second Circuit follow that when they're now told to figure out what's the best reading of the statute?
I gotcha.
And so I don't think that's going to carry a lot of weight anywhere, except in that circuit.
Except that circuit, or if it's from the Supreme Court.
Yeah, and if
it's
it's a district court, forget it. Any district court will
Sure.
follow the new standards.
Their own island.
So
Right.
the Supreme Court may have thought they were doing something, but I don't think they really were.
Okay, another question? Yes?
Yeah, we're just like a few weeks away from a draft of a big, beautiful bill, right?
Well,
How do
right.
you think like Congress got to address that, right? They have a vested interest in having regulation actually help them and close loopholes and things like, do you think they might just for every single provision give a broader delegation of authority to Treasury, or maybe a mini 7805 on steroids just for that bill, or what do you think they will?
I'm not even sure under reconciliation they could do that even if they wanted to. The reconciliation rules are pretty strict. Every provision has to have a revenue effect.
So most likely then a single broad delegation of authority in each section?
Well, yeah, you know, the new bill is, well, first of all, they're likely to, if they adopt new provisions, they're likely to create new problems, new gaps in the statute. You know, it's interesting to know what would happen if Congress did, totally aside from the restrictions of reconciliation, just copy 7805 in every code section. Would that be better than having it in one section? I don't know. It's still no more, it still doesn't meet any more standard of clarity than being at the end. I mean, I just don't know. Would courts give it more weight? I'm less convinced that the particular standard matters very much, the standard of delegation, because in reality, if a statute is truly ambiguous, 50-50, and the regulation comes out one way and they have a pretty good reasoning in the preamble, there's a good chance the court will uphold it. There have been some of those cases since Loper Bright where you kind of come out either way and they went with the Treasury, and that's all fine. But that's true regardless of what the level of delegation is, whether it's 7805 or some more specific delegation. But once you get to a statute that is probably 70% one way and 30% the other, I don't think the level of delegation is going to change that either. They're going to follow the best reading of the statute. That's what Loper Bright tells them to do. So if it's 60-40, I don't know where the line is, but at some point above 50, the statute is the best reading of the statute is to control regardless of what the delegation is. Now, some delegations aren't interpreting statutes; they're just authorizing regs on something. I mean, that's a whole different thing. Like the consolidated return regs, it's just one big delegation. There's no best reading of the statute. There is no statute, and so those, assuming that's constitutional, I mean, those will probably be followed. And then there are cases where the code says under regulations, this is the rule. I mean, can the regulations change the rule in that case? Probably not. So I'm not convinced the particular language is going to make that much difference, if except in the case where, where there's no underlying rule. But if the statute is relatively clear, 60%, I just find it hard to believe it's going to matter.
Yeah, I tend to agree. I think courts, they don't approach these issues with a blindfold and saying, "Hey, let me see where these different new standards take me." They tend to have an idea of what they want the result to be with the case in front of them. And so if they want to uphold a regulation now, before Chevron made it a little bit easier, if they want to uphold a regulation, they're likely to say there was a sufficient delegation and the regulation is within that. If we're just shifting the framework for what I actually don't think it's going to be a significant. Courts are going to do what they want to do, and they'll use whatever the existing legal standard is to accommodate that. I think.
They had more trouble under Chevron to invalidate a reg unless the statute was clear.
I agree. So now it's a little bit easier if you want to.
Oh yeah, the Treasury definitely had more, except for the clear case. The Treasury had a lot more discretion under Chevron than they do now. And
but back then, even under Chevron, if I didn't like what the Treasury Department did, I would say that the statute was. I'll just declare that it's unambiguous and that the. Anyway.
Yeah. By the way, I should mention one of the reasons that the Supreme Court didn't like Chevron is, first of all, they don't like delegations of authority, but they also didn't like the fact that the one administration would come out with a reg relying on Chevron, then the next administration would reverse it, and it was valid also under Chevron. Then the next administration would go back the other way,
right?
And that just didn't look good. And everybody relying on Chevron, and so this way they thought they were restricting some of that. But I'm not sure they realized just all these other problems they were causing as a result.
All right, we've had used up our time, but I said if there's other questions that folks have.
We can. If anybody has anything else, ask now or later.
I just have an observation, which is obviously it's unfortunate we are in this situation, but it's a bit like the whole political system. There's some pendulum, right? The reason I asked about the regulations, which you thought were overbroad is because the IRS and Treasury went overbroad on a number of different regulations, in my view. And I think it's a reaction, but the reaction kind of exceeded, I think, some of the parameters. So now we're in this realm of chaos. Nobody knows what the law is. Everybody can challenge everything, but at the same time, some of the like the preambles you said, right? I remember reading the FTC regs that came out 3 years ago. They were ridiculous regs. They were withdrawn, but not after everybody went crazy trying to adjust to them. So you see kind of the Treasury going overbroad, and now you have this response from the court, which is very conservative. But now it's almost a reflection of the political system we have in the U.S. these days. So it's just an observation.
You know, I would say they went overboard both in the pro-taxpayer side and the anti-taxpayer side. Some of those pro-taxpayer regs were really, I think, pretty egregious, like the guilty high tax exception. Had absolutely no basis in the statute. Some of the BEAT regulations, they just tried to do something that they thought, I don't know if the Congress intended it, but they wanted to work better. Or I don't know if they were lobbied or what, but I think they were equally non-statutory in both sides. And now it's just half of them that are getting eliminated. By the way, even in the Varian case, it's a very interesting fact is, where the statute was sort of clear, was clear that the reg was contrary to the statute. The preamble to the reg said we really had to do this because the statute came out the other way, and that didn't make any sense to come out the other way. And the court relied on that as a concession as the statute was being clear. Right. So that's why one of the reasons they lost. They conceded that they needed the reg to fix the statute. And say, well, you can't do that. Question? Was there another question? No.
Yeah, John?
What do you think if Congress were to start, delegating to Treasury, but requiring them to get final approval for regulations from like the Joint Committee or somebody who worked for Congress, if they brought it back in some way? It's sort of like a hybrid delegation.
I don't know if that would be constitutional for the final say to be in the staff. The Joint Committee is a staff.
Right.
They're not appointed by anybody. They're not government officials. I don't think that would be. There's the appointments clause, which is talked about in that Supreme Court case in the FCC. That's the issue with the subdelegation to to a third party. If somebody has to be subject to the appointments clause to have the power to decide things like that, and I don't think the staff would have that under that.
Oh, thank you.
Great, Mike. Thank you very much. We can easily continue the. Yeah. Again, we do have a reception out in the foyer. We hope to see you there and get to know one another and maybe continue this conversation. But thank you all for being here this evening. And thank you very much, Mike.